the European Convention on Human Rights. But what is true for the convention is also true for Rudolf Bernhardt. To me, fair friend, you can never be old. He had his 95th birthday on 29th April this year. And 5 years ago, for his 90th birthday, his friends, colleagues, family, and students dedicated to him or gave him as a gift the Bernhardt Lecture, which is devoted for a talk on human rights to be given by a younger scholar in the field of human rights. The first Bernhardt Lecture took place in 2016, was given by Ausolya Salat from the Hungarian Academy of Science. The second Bernhardt Lecture was given by Professor Eirik Bjorge from Bristol University. And today we have the third Bernhardt Lecture given by Professor Başak Çalı from the Hertie School of Governance. But first, let me say some words more on Rudolf Bernhardt, who was a director at this Max Planck Institute from 1970 until his formal retirement in 1993. He partly acted as a co-director with his academic mentor, Hermann Mosler. For some years, he was the sole director of the institute until 1981. And then with colleagues, among them Professor Jochen Frohwein, whom I would also like to welcome tonight here. Rudolf Bernhardt has been a judge at the European Court of Human Rights, which he also presided for several months until the court's reorganization in 1998. Rudolf Bernhardt sends his kind regards and greetings to everybody here. He is well. He is following the lecture also via Zoom. I would encourage everybody in the audience now here and recommend to keep the masks on when sitting, because I think everybody feels more comfortable then. But of course, we have here in the room all precautions and the sufficient distance between the chairs. More than 100 people have registered for the Zoom call and will be able to participate in the discussion through the Zoom chat after the lecture. The event is recorded and it's also live streamed on YouTube. I already saw I saw the number of people waiting already for the live stream. And we will also stream and record the discussion. But now some words on our speaker tonight, Professor Başak Çalı, I think is a perfect fit for the Bernhardt Lecture. Başak is a professor of international law at the Hertie School of Governance in Berlin, where she also founded the Center for Fundamental Rights, which she co-directs. She has also founded a Center for Public Law, Global Public Law at the Koç University Law School in Turkey. Başak also holds a permanent visiting professorship at the well-known research program on international courts, I-Courts in Copenhagen, and she's also senior research fellow at, one could say, the competing research program on international courts in Oslo. I've known Başak during her involvement with the European Society of International Law, on whose governance board she sat and where she also acted as the Secretary General. Başak's career unfolded from bachelor studies in Ankara over master studies at the University of Essex. She did her PhD in international law, obtained the degree in 2003 with Françoise Hampson as her supervisor. Başak then moved to the University College of London, where she was a professor until 2014. She then moved back to Istanbul briefly, and since 2016, she's a professor in Berlin. Her research profile could not be more fitting for the Bernhardt Lecture. Başak has extensively published on human rights and also on courts, on comparative international and regional human rights, and she has investigated the intersection and interaction between international and domestic law, and she has especially worked on the implementation and enforcement of human rights, notably under the European Convention of Human Rights. In all this, her approach is markedly interdisciplinary. Although she holds titles in international law, she has studied and worked at departments of political science at the various institutions I mentioned. And I would particularly like to highlight her most recent book, which was published with Oxford University Press in 2015. The book title is The Authority of International Law, Obedience, Respect, and Rebuttal. This book is a both legal and political science investigation on the effects of international law in domestic orders. By authority, Başak understands the capacity to impose duties or to confer power on state officials. And the book's core argument is twofold. First, that international law carries a presumptive weight and minimal deference is owed to international law by all national institutions, including, of course, judges, who must seek to harmonize how political officials act domestically and as a part of the international collective of states. Second, Başak claims that the authority of international law can take various forms, ranging from overriding authority to qualified authority up to a rebuttable authority. In other words, different areas of international law have different authority structures. Başak's approach is very much not about law on the books, but about law in action, informed by empirical methods, including interviews with judges and state officials. And I would now like to give the floor, or rather the screen, to Professor Başak Çalı in her variation on Shakespeare's 104th sonnet.
Thank you very much. So I'll start right from the beginning, and I'm trusting that you can all hear me okay. We were hoping that nothing will go wrong, but of course there's always the Murphy's Law. To me, fair friend, you can never be old. In this well-known Shakespeare sonnet, controversies are abound. Who did Shakespeare write this sonnet to? Was it for a lover? Was the lover dead when these lines were written? Moving away from what the poet intended to what the poem evokes to its reader, to me, the sonnet evokes the notion that even a person ages because of what they do, how they act. There may also always be something new about them. Getting old is also about getting new. It's also about becoming different or indifferent. In the spirit of this sonnet, in this lecture, I pose the following question. Just about to turn 70, how has the European Court of Human Rights aged? Is the court an old, tired institution? Has it renewed itself? Has the court become a different institution to its 20-year-old or 50-year-old self? My answer to this question is, well, let's keep that towards the end. It's an absolute honor for me to address Professor and Judge Rudolf Bernhardt and you all for the third Bernhardt lecture on the occasion of his 95th birthday. I genuinely wish that I could be in Heidelberg right now, but let me assure you that as I am standing in a room all by myself, I am as excited as I would have been if I were in Heidelberg. Perhaps the excitement is even more given our new online existence. Professor and Judge Bernhardt served at the European Court of Human Rights between 1981 and 1998 as judge, president, and vice president. As such, he was one of the human rights lawyers that has shaped the case law of the court and its important innovations in 1980s and 1990s. My first encounter with the court was through the cases brought against Turkey, also in the 1990s. The first ever case of the court that I read line by line was the case of Aktıvar versus Turkey of the Grand Chamber in 1996. This is a central, yet currently somewhat forgotten case law concerning the interpretation of Article 35 of the Convention. The lecture has three parts. In the first part, I aim to put forward the argument that the way that the young and the mature European Court of Human Rights has aimed to undertake the Herculean task of human rights law interpretation was by way of constantly seeking to balance two competing objectives. These competing objectives have been providing an effective protection and effective interpretation of human rights and allowing a space, due deference for human rights protections to develop in their own ways in European and national legal and political contexts. The court has developed wide-ranging interpretive doctrines with the aim of serving either of these objectives. In the second part of the lecture, I aim to argue that the objective of seeking to give due deference to national authorities has started to gain a significant grip over the aging court, with ever more and pervasive due deference doctrines developed by the court at the expense of effective interpretation. In part 3, I consider 2 objections to this thesis. Let's move to part 1. The European Court of Human Rights to date delivered thousands of judgments and decisions. What emerges from this body of case law is no doubt a fine-grained jurisprudence. One may hold that imposing a broader, structural perspective of competing objectives on all the wide-ranging case law of the court is a difficult, perhaps an impossible task. This is, of course, some ways correct. The court's case law can indeed be approached from the perspective of one specific right and the development of jurisprudence concerning that right over time. But it is also the case that both judges, including Judge Bernhardt, and the scholarly community around the court has long identified that the court is, in effect, seeking to make the sense of its task as a regional human rights court for Europe through competing objectives. This is what we may term the European way of human rights interpretation. Just by looking at the Inter-American Court for Human Rights or the United Nations treaty bodies, we also know that this is not the only way. How has the court come to terms with its competing objectives? Through interpretive doctrines. Let's look at effective interpretation first. The court's commitment to effective interpretation is well known in its mantra that the court must provide real, practical, not theoretical or illusory rights to individuals that come before it. This commitment has found at least 5 interpretive forms in the court's case law. The first of these forms is the doctrine of autonomous concepts. This doctrine holds that in order to provide effective interpretation, the court cannot be bound by how legal concepts are defined as a matter of domestic law in its member states. The second form is the living instrument. The court has embraced the principle of living instrument, holding that the convention interpretation must reflect a development of moral, social, and political progress over time. The third form is the moral reading of the convention. The court, under this, has advanced that the interpretation of human rights law must be sensitive to the moral foundations of human rights. The fourth form is the recognition that there is a distinction between negative and positive obligations, but that this is a fine line. Not only the scope of rights, but also the scope of duties must evolve over time to make the convention an effective instrument. The fifth form concerns the non-automatic and flexible interpretation of exhaustion of domestic remedies. All of these forms, interpretive doctrinal forms taken together, have meant that the court has found violations of the convention, even when there was good faith on the part of national authorities. Whilst the above doctrines define an important role for the European Court of Human Rights to offer effective protection, the court has also given voice to the counter-objective, the respect for the political autonomy and capacity of states to determine the scope and violation conditions of rights. Whilst these are sometimes called margin of appreciation or subsidiarity, I do not find these umbrella concepts helpful, as they fail to capture the diversity of due deference doctrines that the court has developed. The first formulation of due deference doctrine is epistemic deference to national authorities. The court held that national courts are decision makers were epistemically better placed to interpret the scope of national laws as well as assessments of factual evidence. The second formulation of due deference has been based on legitimacy concerns. The court first mobilized the idea of moral distance between Strasbourg and national communities, when it held that the national authorities may be better placed to assess how much moral progress or political progress is possible within a political community due to their close and direct contact with the forces in that community. The third formulation of due deference has turned to the democratic variant of legitimacy. The court has recognized that democratic procedures are better placed to resolve reasonable disagreement on rights interpretations. Alongside these, the court has also created mediating doctrines that seek to iron out the tensions, inevitable tensions, between the competing objectives. The European consensus or global consensus doctrines seek to establish when the court will act as an effective interpreter. The court has held that if it is capable of identifying a European or global consensus, the objections based on due deference grounds must yield to effective interpretation. As the preceding discussion makes clear, the court has over time created doctrines which are capable of lending support to either effective interpretation or due deference. This is a central structural feature to make sense of the court's case law. Yet, as the court is about to turn 70, we see a significant shift in the rhythm of the court's long-term struggle in balancing these competing objectives. To put it differently, we see that the variance of due deference doctrines to be more heavily populated than effective interpretation doctrines. Due deference, as a consequence, has gained structural priority over the objective of effectiveness. So this is the beginning of part 2. How has this come about? Due deference has first become a pervasive principle governing Article 35 of the Convention. It is well known that the European Court of Human Rights requires exhaustion of domestic remedies, but it has long established that these must be at the exhaustion of effective domestic remedies. When the jurisdiction of the European Court of Human Rights significantly expanded, just as Judge Bernhardt's term was coming to an end, to Eastern and Central Europe, when the court has lost its filtering mechanism, the European Commission on Human Rights, and when it has become a full-time court in a space of a very short period of time, the court has inherited, well known, a major backlog of cases. In the light of this, the court has faced an important dilemma. On the one hand, a flexible reading of the admissibility criteria has been understood as the gateway to effective rights protections. If a case does not reach the merit stage in Strasbourg, the whole potential of effective interpretation is stillborn. On the other hand, the court could not handle cases it has received and had incentives to limit the number of cases it receives. This resulted in affording more deference to domestic authorities at the admissibility stage. This tension, brought about by the expansion of the court and its institutional reform, has also spilled out of the court's judgments to writings by judges, most notably late President Wildhaber, meetings of state parties, and political declarations of the masters of the convention. It has also led to formal amendments in the admissibility criteria. It has further given way to the pilot judgment procedure, through which the court has institutionalized handpicking a single case out of thousands to identify a systemic problem and then ask the domestic authorities to address that problem. These developments altogether have meant that the due deference objective has become dominantly employed at the admissibility stage, admittedly as a coping strategy with a large number of cases. The very recent case from Turkey, that is Köksal versus Turkey, is a final progression of this pervasiveness. In this case, the court has expanded its due deference doctrine at the admissibility stage into a novel territory by accepting that a domestic remedy that was not yet in place at the time of the inadmissibility decision was capable of attracting due deference as a domestic remedy under Article 35. Due deference has also become more pervasive at the merit stage. This is exemplified in the court's ever-increased willingness to take its national partners more and more seriously as co-interpreters of the convention. This emphasis is distinct from the court's earlier recognition that domestic courts enjoy epistemic superiority in assessing facts. Rather, it relies on the evaluative trust placed in national authorities. This may be a good time to mention a German case. In the Van Hannover versus Germany case of the Grand Chamber in 2010, taking seriously the evaluative abilities of domestic courts saw a clear pronouncement when the European Court of Human Rights held that it will require very weighty reasons not to respect the evaluative exercise carried out by the German Constitutional Court. The Grand Chamber judgment is crucial in the sense that it has moved the due deference objective also into a new territory, that of due deference to trustworthy and responsible domestic courts and authorities. As such, the assessment of trust towards national authorities have become paramount in the case law of the court. In the words of the current president of the European Court of Human Rights, President Spano, every national judge is a Strasbourg judge. This decentralized view of the interpretation of the European Convention on Human Rights stands in stark contrast with the effective interpretation doctrines and diminishes the space for finding good faith violations of the Convention. What I have aimed to show in this discussion is that due deference doctrines have become more and more pervasive as a structural feature of human rights interpretation in Europe. This is not necessarily about how often they are used in numerical terms, although many scholars of the court have also noted that the use of marginal appreciation in the case law of the court has increased over time as a matter of absolute numbers. Instead, I seek to show that the structural competition between effective interpretation and due deference has gone through an important change. This change is pervasive. It runs through the admissibility case law as well as the merits reasoning of the court. Let me now consider two objections to the central thesis of the talk. The first is that effective interpretation is live and present. The court may be old, but it still is ever so innovative. The second objection is that the structural evolution of due deference is simply in the nature of things. Aging means becoming different. This is the simple way of understanding it. I take these objections in turn. Is effective interpretation alive and well in the court's case law? An important argument put forward in support of this, of the court's innovations in its old age, is the burgeoning Article 18 case law of the European Court of Human Rights, where the court not only rejects any form of deference under this case law, but goes a step further to identify improper purposes for restricting rights. In this respect, it may be argued that when the court finds an Article 18 violation in conjunction with another article of the Convention, it is deepening its effective protection objective by developing an important distinction between legitimate and illegitimate purposes for restricting rights. It is true that the court has delivered over 15 judgments against Azerbaijan, Russia, Turkey, Moldova, Georgia, and Ukraine since 2004, holding that the actions of national judicial authorities in the restriction of rights pursued illegitimate motives. The court has held that the authorities in these countries aim to silence or punish political opposition, human rights defenders, journalists, and other members of the civil society. Yet it is not clear to me whether we can point to the Article 18 case law of the court as a counterbalance to the deepening and pervasiveness of the due deference doctrines of the court. What the court is doing under Article 18 case law is to find aggravated violations of human rights, in particular in the domain of deprivation of liberty. In most of these cases, the court will have already found a violation of one of the substantive rights based on its arbitrariness review that it has long developed. As such, the court is using Article 18 to signal to the European community as a whole that some members of the Council of Europe have seriously fallen out of line with the Convention. It is in this respect that whilst the Article 18 case law of the court is indeed new, it does not act as a counterbalance to the pervasive development of due deference. What is more, there is evidence pointing in the opposite direction. The European Court of Human Rights now sees no contradiction in finding an Article 18 violation against a state because the executives in that country influence the judiciary and also employ due deference doctrines at the admissibility stage with respect to the very same country. This means that due deference objective is not only at work with respect to trustworthy or good faith interpreters of the Convention, but also with respect to those who have been found to undermine the essence of the Convention. The second objection against my thesis is that there is nothing problematic about the due deference being more pervasive in the court's case law as the court turns 70 and the Convention turns 70. this is in the nature of things. According to this objection, the reason why the subsidiarity idea and its accompanying doctrines have become so pervasive is because the European Court of Human Rights has largely been successful for the most part in its role as a norm entrepreneur of human rights. If many judges around Europe have indeed become Strasbourg judges, then they have to be respected and celebrated as such by Strasbourg. As attractive as celebrating the effectiveness of decentralized protection of human rights may be, this view depends on a very optimistic and complacent view of the state of human rights protections across Europe. A first concern with regard to this view is the difficulty of national judges to act as impartial arbiters of convention rights domestically when the domestic laws in place, say in the context of immigration, asylum, austerity, the COVID pandemic, or the climate crisis, limits their potential as Strasbourg judges. A second concern is that most domestic courts may indeed follow the well-established case law of the court, but they may not find themselves well placed to develop it further. As articulated in the maxim of no more, but certainly no less, in Ulla by the House of Lords, now the British Supreme Court, this point underlines that most national judges accept the fact that the case law of the European Court of Human Rights need to be developed in Strasbourg and not in the hands of domestic judges scattered across Europe. The mantra that each domestic judge is a Strasbourg judge, therefore, do not do justice to the limitations of domestic judges, let alone parliaments, offering interpretations of the Convention as an effective living instrument. It is therefore a genuine risk, there is therefore a genuine risk of no one speaking on behalf of human rights interpretation in Europe. In a recent empirical study that I have carried out with my two co-authors, published in the German Law Journal, we have found some important implications of this latter point. Half of the non-refoulement migration asylum-related case law before the 4 United Nations human rights bodies are brought against states that are subject to the compulsory jurisdiction of the European Court of Human Rights. An important reason for this is the pervasiveness of due deference doctrines employed in the court's migration, asylum, and deportation case law, despite the ever-growing migration restricting policies in Europe. Those seeking to protect the rights of refugees in Europe, therefore, are turning more and more to the United Nations treaty bodies, even though these bodies are at best soft courts, in search for normative leadership in human rights interpretation in the context of migration. I started this lecture by asking, how has the European Court of Human Rights aged? In this lecture, I have argued that in its process of aging, the European Court of Human Rights has come to favor one of its long-standing structural objectives, due deference, more than its other structural objective, effective protection of human rights. Along the way, the court has become a close but not necessarily a fair friend of domestic judges and parliaments. The court's interest in the progressive development of international human rights law as a leader of human rights interpretation has started to wane in this process. What is more, in slowly settling into a new binary between being a good friend of good faith interpreters and somehow tough on bad faith interpreters of the Convention, the court may have also opened up itself to the charge of employing a standard of civilization, holding that the contemporary practices in mostly Western Europe are just good enough. Is the European Court of Human Rights at 70 a fair friend for human rights? It seems to me that this is a question that should continue to occupy us for many years to come. I wish many happy returns to the European Convention on Human Rights and to Professor and Judge Bernhardt.
Virtual room can hear me?
I can hear you right now, yes.
Okay, so that means that everybody, I hope, hears, and I hope that you also heard the applause.
I didn't hear the applause, but I'm imagining it. Thank you. I've just heard it.
The floor is open for discussion, questions and comments, and I would like to again explain the rules. We'll take questions here in the room, and people asking questions here will come to the podium where I now stand and ask their question here, because we have the microphone only here. And we will also take questions from the chat, which I will read, and I will read them from the table where I sit. So you won't be able to see the person asking from remote, but you will be able to see persons here. And I would like to give the first the first question will be asked by Professor Frohwein.
Professor Chan, thank you very much for a most interesting analysis of the developments of the European Convention on Human Rights. I may say that I speak from a background familiar with the early developments of the convention. I was a member of the commission between 1973 and 1993 and vice president for many years. And as you may certainly know, at that time, a lot of the case law of the court was prepared, in fact, by the commission. Your thesis that the court has now turned to a position where deference to national institutions plays a bigger role than at the beginning may be to a certain extent correct. And it may be also correct, and I think you hinted at that, because the importance of the case law of the European Court of Human Rights has been recognized and implemented in many of the convention states, not in all, I'm afraid. You mentioned some of them, and I'm afraid to say that your mother country is one of the countries where real problems of that sort exist. And I think, and you have not mentioned that issue, that the court in fact showed deference to Turkey in a situation where it should not have done so. And that is after the coup and the reaction of the Turkish organs to the coup, where, as we know, I mean, thousands of people have been deprived of their liberty, have been interned, and so. And what the court did was, in fact, decide most of these cases on the basis of non-exhaustion of domestic remedies, without, in fact, really scrutinizing whether there were effective remedies in Turkey. I argued at the time that this should be done in a big oral hearing in Strasbourg with the people and the Turkish lawyers who are of the opinion that there are no effective remedies would have had a say. Now, a few other small points. If I accept your idea that one must be careful not to show too much deference to the national organs, I would personally argue that in many of the cases which have become most important landmarks of the court's decisions, the states have in fact complied. Most of the states, I say again. Your remark concerning migration cases, I think that is an important issue, although I doubt very much whether really the United Nations system can be of real importance there. I suppose this is an area where the states really have to do more than they did so far. You made a short remark that Western civilization criteria may become, if I understood it correctly, the main conclusion for the European Court of Human Rights. There may be something to it, but it may be based on the idea that what has happened in Western Europe, and unfortunately not in all the countries which have become members of the convention, is really very much in line with the basic ideas of the convention. Thank you.
Thank you very much, Professor Frohwein. Başak, do you want to answer immediately? And then I will call on other questions, or do you prefer that we collect some questions?
There were a couple of points here. Maybe I can briefly reflect on some of those points and give everyone a bit of more time, if that's okay, Anne. So I'll make a few points now. Is that okay? I don't hear you at the moment, hoping that this is temporary. Do you hear me?
Yes, I hear you. For some reason, the microphone from my table doesn't function, so we can speak only here. And yes, please go ahead with your answer.
Okay, well, I just wanted to first thank you for all these comments. So one of the way in which we can understand the due deference given to Turkey is to look at it from this more general perspective that I try to present. So I don't think the situation was that the court has done something specific in relation to Turkey, but it actually, the way that it decided in the Turkish cases reflects the pervasiveness of the deference idea. So in a way, this pervasive development of deference has led to what you have identified as a problem, I think, in the Turkish cases. In relation to court's implementation record, but not the court, it's not necessarily obviously the court's fault, but the state's implementation record of the judgments, we see that there is still quite a lot of problems in that field. But I will bracket the implementation crisis of the court maybe as a separate issue. The time that it takes for states to comply with the judgments are taking a very, very long time. And there are quite a wide range of states from the full spectrum of the Council of Europe that are not effectively complying with the judgments. And some people have also called this the implementation crisis. Coming to the UN system, I think you're absolutely right. But I think it shows us again an interesting indication. Why would one choose to go to the United Nations treaty bodies instead of the European Court of Human Rights? I would have thought that the choice would have been very clear, but our empirical study have shown that a lot of individuals in Europe are worried about the European Court's approach to migration and are just turning elsewhere to address these issues. I don't think that the final argument about creeping of the civilizational standards, this is, I think, a risk with over-pervasive use of subsidiarity doctrine. So I do identify it as a risk. I wouldn't say that this is an intentional sort of action by the court, but it is a consequence. It may be a consequence of how it's perceived. And after all, it is very important how human rights courts are perceived by its audiences.
Thank you very much. Başak, do you hear me now?
Yes, I can.
Okay, great. So I'll take the next question from Sylvia Steininger from the room. You have to wait a minute until the researcher goes to the podium.
Okay, hi. Happiest birthday to Professor Bernhardt, of course, and many congratulations, and thank you also to Başak for, I think, an excellent talk. I actually have a question which is kind of related to your last point, so how the court deals with external audiences. Because I was wondering if this clash of principles you see in the case law of the court can also be translated in the way that the court deals with external audiences. Because my question was, when I looked at the title, is, are we actually still talking about the same court? The court in the ages of Professor Bernhardt and Professor Frohwein looks very different than the court we have at the moment. Also, the judges are very different from very different backgrounds. So I would be interested in your view about what kind of court do we have at the moment? How does it relate to external audience? I know you were very critical of Professor Judge Spano's recent trip, I think, to Turkey. And is that something that we can also see is kind of similar to the reflection in the jurisprudence of the court? Thank you.
Thank you, Sylvia. Başak, do you want to respond?
I think Sylvia has reflected or given a bit of a clue of an answer. I think, yes, my thesis is that this is a different court than the court of Judge and Professor Bernhardt. So this could be also summed up as one of the ways of putting the thesis of this. And we have to, of course, accept the fact that the court has always had this objective competition. And we have criticized the court for doing it wrongly in one way or another. But one of the things that in the earlier jurisprudence and scholarship that was accepted is that there was this rhythm of the court oscillating between one side to the other. So the kind of court that we have right now is the one that more frequently oscillates both at the admissibility and at the merit stage to one direction. What does it mean for the audiences? So it will depend on which audience you have in mind. Obviously, the court is a much more of a relaxing court for the external audiences of domestic judges, national parliaments, but it also is a court that is full of disappointments for applicants, for human rights defenders, for civil society, or for those who seek a more coherent form of interpretation. For the external audiences, imagine other human rights courts and bodies. Of course, the court is no longer a leader in human rights law interpretation. It is a lot more conservative, and it is compared to others. And you can say there's nothing wrong with that, but I think we could still say that the way that external audiences see the court has also significantly shifted over time.
Thanks, Başak. I will now take some questions from remote and then again from the room. The participants in Zoom see the questions in the chat, but Professor Çalı doesn't see them, so I have to read them also for the participants following the live stream and who are not in Zoom. So Justin Kahe asks a question about ULA and the mirror principle, which you mentioned. Leaving aside the question of backlash, he asks, is it desirable that national courts look to Strasbourg for leadership rather than taking the lead themselves? Strasbourg adjudicates for a far more diverse community than most domestic courts. And to reprise the case of ULA, he says that this can be seen as a problem. Başak, do you want to answer?
Yes, I mean this is also voiced in the court's attention paid to different variants of due deference that I've tried to unpack as well. Now, of course, there are a couple of interesting questions about how diverse are the communities. We always take it for granted that the communities of the Council of Europe are diverse, but there are also some questions about how what kind of weight we should accord to that diversity. And the court has also tackled with that question, right? In trying to formulate sometimes wide or narrow margins of appreciation. So that problem is always there. I would not underplay that problem, and the court's also strategic objective to be followed and not to be subject to backlash is also there. But the question is it the only concern for this court? So this is the question that we have to think about. I don't hear you at the moment. I hope you can hear me.
An engaging talk. You mentioned do you hear me? Yeah.
Yes, I can hear you now. Thank you.
You mentioned the living instrument doctrine, and you also mentioned the climate crisis. So I want to follow up on those 2 points and connect them. So the living instrument doctrine means that the convention needs to be adapted to contemporary challenges and changing conditions. And obviously, one of the biggest challenges that humanity faces today is the climate emergency. And the European Court of Human Rights already, in its case law, recognizes that environmental harm can undermine convention rights, and it is generally accepted that climate change is a serious or poses a serious threat to human rights. And a couple of weeks ago, the Council of Europe organized a high-level conference in which several judges from the European Court of Human Rights also participated on the topic of human rights for the planet. And on top of that, the Dutch Supreme Court last year decided the landmark Urgenda case, in which it derived positive human rights obligations from Article 2 and 8 of the Convention. So positive obligations of the state to combat climate change, basically. So if we see the Supreme Court, the Dutch Supreme Court, as a co-interpreter here, are the signs pointing towards a green interpretation of the convention? Can we expect the European Court of Human Rights to play or to resume a leadership role in Europe on the issue of climate change? And I would be curious to hear your assessment on whether we can reasonably hope for the court to soon deliver a landmark judgment on basically a green interpretation of the convention and extending or deriving positive obligations from human rights on states to take preventative measures against climate change. Thank you.
Thank you.
Thank you, Saskia. Yeah, Başak, go ahead.
Thank
and then
you,
I would like to take some more questions from the chat, because there are so many questions, and that I will take them in a group. But maybe you answer this one, and then I will read some more.
Thank you. Thank you very much for this very comprehensive question. Perhaps one of the good news. I mean, I don't. It's very awkward to say that climate crisis is good news. Maybe I have to reformulate that. But one of the things about the current human rights climate is that there are some significant opportunities for the court to renew itself, to come out of this very aging, very deferential mode that it has been hiding itself for quite some time. And I think the climate crisis, human rights law litigation is one of those fields where there is always a potential. As you've highlighted, the court has doctrinal resources to address some of these complicated issues. You identified living instruments and positive obligations, but of course you can add to this the notion of autonomous concepts as well. So there are lots of ingredients there for the court to seize. Yet if we look at how the court has been dealing with areas where there is no clear European or global consensus, in this case, any European consensus on how to take national measures on climate crisis, and this pervasive use of subsidiarity, of course, the chances of the court seizing that moment does not look very likely. But having said this, of course, this is exactly an opportunity for the court to renew itself, to recreate itself, and I think this is how we may think of this. We may think of this challenge. But according to my thesis, this is not very likely. The court wouldn't run on one domestic court judgment to be able to establish an understanding on environmental harm in the context of climate crisis. I hope I'm wrong.
Thank you very much. Can you hear me?
Yes.
Okay, so there have been questions in the chat about deference. For example, Ed Bates asks, is deference here to stay? And what else could the court do in order to counter populist attacks? Matthias Goldman also observes that deference doesn't look good for weaker participants in the entire game. So these are questions about deference. A second group of questions asked, amongst others, by Professor Anousheh Farahat is about your conception of human rights as opposed to maybe a different conception underlying Professor Frohwein's remark human rights could be seen either as transformative and very dynamic, or as protecting the Western European status quo. Maybe we would like to hear some remarks on these points, and then I will call on other people here in the room.
Thank you. Thank you for those clusters of questions. Is deference here to stay? So deference was there right from the beginning. I'm not in disagreement with those who say that subsidiarity was there from the beginning. The deference was there from the lawless judgment from 1960 and onwards. But the question is obviously when deference is to be used, under what types of circumstances. And I think this is the question that the court hasn't really addressed very clearly. If a certain issue has not been clearly interpreted by the court, if there is no well-established case law, if there are no clear standards and concepts, should the court defer to domestic authorities just trusting their own interpretive judgment? And I think this is the kind of the very core of the question. So deference in some forms and shapes, I think, should be here to stay, but pervasive deference and sort of this automatic use of deference, unreasoned uses of deference should not be here to stay. And this is something that we see more and more frequently in the court's case law, when the court very easily mentions very weighty reasons doctrine in migration and asylum cases, which I'm not so sure normatively how we can justify this automatic use of deference in Europe, in Western Europe, for example, in those cases. And of course, deference has winners and losers. You're absolutely right about that. And of course, there must be some measure of some people do win and lose. It doesn't mean that applicants always need to win a human rights case, but the rhythm of who is winning and who's losing is changing, and this is sort of an overboard type of a development. And this is something that should concern us. This should genuinely worry us. And these losers are not only living in Turkey or in Azerbaijan. I think this is an important point we should highlight. Those are also living in the UK or in Germany or elsewhere, because the admissibility difficulties, the difficulties of reaching this court has become so different that most of the losers you don't even see in the judgments themselves. I think also for the question about the transformative conception of human rights and more of a reflection of the, whatever exists in Europe, which is one way of understanding the civilizational standard arguments going back to the earlier centuries. One of the important things about the European Court of Human Rights right from the beginning was, I think, its transformative potential. And the transformative potential showed itself in the cases against Western European states, in particular the cases against, for example, the United Kingdom, also cases against Germany in the 1980s. So the courts, one of the things that I admired about this court was exactly not falling into the trap of civilizational standard in its early and sort of younger ages. So it's something that we should protest, that the aging court is seemingly, or has, it may be seen to be falling under this trap. So, and I think this is something we should worry about in relation to what this court has achieved in its more younger versions.
Thank you very much, Başak. I'll now ask Professor von Bogdandi for a question in the room.
Yeah, hello. I must say I'm deeply sorry. I'm deeply sorry because it has been such a wonderful performance that I would have loved to see you live, to see it live here. That would be even more wonderful. So thank you very much. My question comes as an interpretation of your title. You say, "To me, fair friend, you can never be old." Listening to your talk, it seems to me that the line could be, as I truly love you, fair friend, I will always criticize you to make you better. That's the feeling that I received from your talk. And that is now to challenge you a little bit on the critical note that you gave us. In the symposium in which the two of us have just participated, one of the outcomes was that in the last 20 years, the European Court of Human Rights has easily overtaken the Federal Constitutional Court as a point of reference for developing individual rights. And that is not just in Europe, but that is worldwide. So when formerly institutions, courts outside Europe turned to perhaps the jurisprudence of the Federal Constitutional Court, now they turn ever more and far more to the European Court. And it seems to me that those courts do not turn to the European Court when they want to give in, but they turn to the European Court when they want to advance their jurisprudence. So it seems to me that in the jurisprudence of the European Court of Human Rights, there is something which is very progressive, and even more so than many domestic courts. So my question is now, in comparative lights, wouldn't you stress that the court maintains its basic thrust of advancing the issue and the cause of individual rights?
Thank you. So this perhaps also comes or ties in with the previous question about what is the purpose of the European Court of Human Rights. So is it about keeping it clean and simple to the basics? So is it there for the protection of the basics, and then or is it for something else? So there are two points here to consider. One is, what do we mean by the basics? So one of the things that we celebrate about the court is that it's said that this is a living notion. We have to understand basics in the developing sort of moral, social, and political conditions, and so on. And a lot of the very exciting sort of references made to the European Court of Human Rights have to do with the other side of the objective. It has to do with exactly with the effectiveness objective and the way that the court has developed. And I think this has been celebrated, and maybe the time lapse of this doctrine affecting others have taken time. But of course, the European Court of Human Rights also has learned from others, right, when doing it. So it wasn't just the European Court developing that. So I think there may be a time lapse between what parts of the court's case law is being celebrated and what the court has been doing, in particularly in the past decade or so. So I think that might invite us to a very interesting empirical study. Which cases of the European Court of Human Rights are celebrated and cited? And I don't think we will find a huge range of these pervasive cases that are focusing on different notions of deference. But I won't speculate further, but this will be my hunch about when the courts turn to the European Court and which part of its case law they actually do turn to. It's a bit odd if everyone is quoting Airy from the 70s and Marx from the 70s, which means that they're not able to find some new cases to quote from the court.
Thank you very much. I will read some more questions from the chat and try to summarize them a bit. Rafaela Kunz asked whether how you see the critique against human rights inflation, and whether you see that human rights are generally in crisis, pitted against the democratic process, and what the European Court of Human Rights could do against this crisis. There is also another question by a participant, whether the court could use Article 46 more to give guidance to states.
Mm-hmm.
And there have been zillions of questions about deference. You answered them, but Caroline Moser asked what other options of deference you see. Other participants asked whether deference should depend on the types of rights. Others asks whether deference could be measured using the concept of epistemic superiority instead of authority. So everybody is very worried about deference. Ger Ulfstein asks, what about deference towards domestic courts applying the court's own legal methodology?
Mm-hmm. Yeah.
And Alexandra Kämmerer asks about the margin of appreciation instrumentalized nowadays. That would also go into the deference cluster. So now this is for you maybe to pick and choose, and then I'll come up with more questions from the chat.
Okay. Wow, they're quite a wonderful range of questions here. So this notion of human rights inflation is a curious one. It depends on one's understanding and one definition of human rights. If you understand human rights to only correspond to some basic concerns, then of course you have to define what those basic concerns are, and then this notion of trivialization of human rights. But this is, I probably will give a pretty long-winded and not probably a fantastically clear answer, because it depends what is meant by human rights inflation. So living instrument doctrine and interpreting rights in the change of living, changing moral, social, and political conditions, to me, for example, is not human rights inflation. It is about interpretation of rights in changing contexts. So those who use human rights inflation have a very particular idea, a much more of a static idea of what rights and in what scope need to be protected. And therefore, they talk about, in a more negative or in a pejorative sense, of human rights inflation. So this is a very theory-sensitive question in so many different directions. I think once you're in the business of interpretation, once you're in the business of legal interpretation of human rights, you are bound to expand, derive new rights or new duties. And I think you can't easily get out of this in the scope or in the context of inflation. So those are my very broad views, but I think we need to understand what concept of human rights is mobilized when one talks about so-called human rights inflation, and there are different accounts of that. What the court can do in relation to the democratic crisis, and of course, one of the things we can say is that, what can the court do? I mean, the court is only able to deliver well-reasoned judgments, and as Armin was saying, hopes that they will be taken up and used and mobilized by others. So the court's tools are very limited. But of course, the court can define a lot better, maybe moving on to lots of other questions about deference, what its conception of deference is, and what its conception of effective interpretation is a lot more clearly in each and every case, rather than what we see in the court's kind of a copy-paste approach to saying, we require very weighty reasons, and the national court has given a bunch of reasons, and so on and so forth. So this is the only tool that the court has. It has to be responsive to something that was mentioned earlier as well, responsive to those who turn to the court to protect democracies. It has to be responsive to them. This is something that I think the court has a duty to do when the democracies are undermined. And then it has to take the claims, the concerns of those who litigate about democratic or rule of law decay very, very seriously, regardless of where these cases come from. Article 46, I mean, Article 46 is something, again, I haven't mentioned Article 46 and deference. And of course, the court's sort of more standard, one of the standard understandings of deference is dear all, just as I was trying to answer a couple of questions you had, the internet where I am has failed for about 10 minutes for absolutely no good reason. But it was an absolute pleasure to interact with you in this online environment. And I look forward to engaging with some of you further on the questions. Thanks again for the invitation. Happy birthday, European Convention, and happy birthday, Judge Rudolf Bernhardt. Thank you.